Hey, everybody. Good afternoon. My name is Calico Castile. I work on the digital side here at the National Organization for the Reform of Marijuana Laws. And I'm joined today by our Deputy Director, Paul Armentano, who's going to talk today a little bit about workplace drug testing and how, over the years, as legalization has come onto the scene and as the shifting attitudes around marijuana are evolving, how those are actually affecting workplace drug testing policies and procedures. So I want to go ahead and welcome Paul here today. Thank you for joining us, Paul.
Hey, thank you. It's good to be here. And I think it's a really important topic. I know we get a lot of questions on Facebook and sent into NORML.org about drug testing and say my state's gone legal. What's this mean for drug testing? I thought it'd be good we sit down and chat about it.
Absolutely. I know we have a few questions that we're going to just kind of start the discussion with here today. But if you guys have questions and you're watching here live on Facebook, please feel free to drop some questions into the comments. I'll be sure to look through them throughout this discussion and make sure that we can try to answer them for you. So I think just kind of kicking things off and sort of laying the foundation about sort of where things sit now as it relates to workplace drug testing. I know that there are obviously the sort of difference between state and federal law. And there are some states that have legal cannabis, but some of those places are still drug testing themselves. How many states have actually enacted laws protecting cannabis consumers from job discrimination?
So where we see this most often right now is in states that have implemented medical access programs. Right now, there are 36 states where patients may legally access cannabis and cannabis products when authorized by a physician. In half of those states, so in 18 states, those patients that are registered in those programs are protected from discrimination in the workplace. In other words, in those states, employers cannot take action against an employee or someone who is applying for a job simply because they are a state registered medical marijuana patient. Now, people are probably asking, why don't those protections exist in all 36 of the medical access states? And the answer is actually fairly straightforward. When some of these initial laws were adopted, such as California's 1996 Compassionate Use Act, or similar medical access laws that were passed in states like Oregon and Washington in the late 1990s, provisions protecting patients from workplace discrimination were simply not included in the language of those ballot initiatives. Fast forward a decade, 2 decades since then, advocates realized that it was really important to have those protections and include those protections in statutory language. So beginning in the 2000s, these initiatives to allow for medical use began to include provisions protecting employees. And when legislatures began enacting some of these measures, they too included those provisions. But right now we're in this sort of unique situation where many of the more recent states to adopt medical access legalization now also protect employers, whereas many of the initial states that passed those laws, like California, Oregon, Washington, they do not.
That's super interesting that there's a sort of difference between states that may have done changes for the medical side long ago and the ones that are just coming online. What do you think that really is that difference on why some of these states who we would think of as being progressive on these issues are a little bit behind on?
Well, because lawmakers have not gone back and sufficiently revisited those initial medical access laws to provide these protections for employers. I mean, for employees. And it's certainly not because we are not agitating for those changes in policies. We are lobbying actively in most legal states, whether they're medical states or adult use legal states, to have employees be protected from employer discrimination simply because of their off-the-job cannabis use. In some legislatures, politicians are still fairly resistant to that message. In some other jurisdictions, lawmakers have been more accepting of it. But there's definitely a learning curve that's going on here.
Well, right on. Like you said, it's not a matter of not trying, but it is not actually doing the step of going back and evaluating those laws. And obviously, there's been some changes even at the municipal level. I know some major cities like Atlanta, New York City are recently enacting municipal laws protecting cannabis consumers. Can you elaborate a little bit about what's happening at the local level?
Sure, this is a really important trend. So while, half of the medical marijuana access states have these protections for employees, almost none of the adult use legal states enact those same protections. The sole exception is the state of Nevada. Their legislature a couple of years ago uh, discussed this issue and said, hey, in the state of Nevada, the adult use of marijuana is legal. Therefore, employers shouldn't be able to discriminate against employees who use marijuana. And they passed legislation that says in the hiring process, an employer cannot give a pre employment drug test for cannabis. And if they do, and that would be employee fails, they cannot choose to not hire that employee because they failed that drug test. But thus far, Nevada is the only state with that broad protection. That brings me to the question of what are municipalities doing? All politics is local. We've all grown up hearing that. And in many cases, when it comes to marijuana policy, it may be easier to pass local changes than it is to pass statewide changes. Because when you're trying to enact local changes, it may be a matter of simply convincing 4 or 5 members of a city council to pass a new municipal ordinance, as opposed to trying to convince majorities of the House and Senate of your state and then convince the governor to sign those changes in the law. So because there's this recognition that so many employees still face discrimination in the workplace for their off-the-job use of cannabis, and because there's a recognition that many state lawmakers have been slow to respond to this issue, what we've seen is advocates and local lawmakers in a number of major metropolitan areas, New York City, Washington, D.C., Atlanta, Richmond, Virginia, Rochester, New York. These local lawmakers have passed their own municipal ordinances by city council votes or by an edict of the mayor to simply ban or bar employers from discriminating against employees who use cannabis, regardless of whether it's for medical purposes or for recreational purposes. What's really interesting about some of these municipal laws, like for instance in New York City or in Atlanta, is that these measures protect adults who use cannabis at home in states where the adult use of cannabis isn't even legal on the state level. Yet nonetheless, these cities have said, if you use marijuana at home in our city and you apply for a job, that employer cannot discriminate against you simply because you use cannabis. Again, even though cannabis may not be legal under state law. Those are very progressive actions that we're seeing being taken on the local level, and it should really encourage folks to know that they can make a difference in their city, in their municipality. They can change these policies at the local level, and that local lawmakers are receptive to this messaging and to making these changes.
That's super interesting, talking about Nevada being the only state that has that broad protection, but then these municipalities where, frankly, you're a little bit closer to your lawmakers and you can have those sort of more personal conversations to where they're actually seeing you as a voter and actually are afraid of what you may do with your vote if they're not working with you on that issue. So it's interesting that you could find more leverage points at a local level than you can, as like you're saying, at the state level.
It can also be much more expedient. City councils tend to meet all year round, whereas your state legislature may just meet in the spring for a handful of months. Again, you can get a provision or an ordinance introduced at a city council meeting. It may be voted on by the end of the meeting. It might be enacted by the mayor within 2 weeks, much faster than legislation ever passes at the state level. Again, as we saw in Atlanta, this was simply a decision made by the mayor of Atlanta to end pre-employment drug testing for non-safety sensitive positions. That was done with the stroke of a pen. That's how quickly local changes can take place.
That's also a great point in terms of like how quickly you can get something done rather than all of the machinations of a state or a federal policy procedure. So that's awesome. I'm curious, now you have some of these municipalities, like you said, even in states where it's not legal to possess marijuana, but are already doing this action protecting from workplace discrimination. Have the courts weighed in on this at all around the sort of issue about workplace drug testing? And if so, how?
Sure, the courts have certainly weighed in. Uh, Specifically, what we saw is in, again, the early years of the adoption of, for instance, medical marijuana access, there were a number of different instances where there was litigation on the part of patients who are asking for relief from the courts. We saw this in California, Oregon, Washington, Colorado. Unfortunately, again, in these early incarnations of states with medical access laws that did not include explicit provisions protecting patients from discrimination, the courts were no help. The court said the language simply isn't in the law to protect these patients. And absent the language being in there, the courts, we are not going to overstep our authority and essentially engage in judicial activism. So unfortunately, until about the mid 2000s, the courts in virtually every state ruled in favor of the employer and against the employee. That shifted starting in around 2015, where since that period of time, we've seen the state Supreme Courts in now around 8 or 9 different jurisdictions all rule in favor of the employee and say that these employers can no longer discriminate against individuals that are using cannabis compliant with the laws of their states. We've seen this in Massachusetts, Rhode Island, Arizona, Connecticut, and a number of other states. Now, one of the reasons we're seeing this change in the court's attitudes is likely because, again, these are states that have come on board more recently and have written explicit statutory language saying that employers cannot discriminate. Once that language is there in black and white, the courts have very little choice but the rule that, in fact, the law is the law and employers need to follow the law. Interestingly, some employers in these court challenges have argued that because cannabis is illegal at the federal level, they should not have to follow state law. They should still be able to discriminate. The courts have said, no, we acknowledge it may in fact still be illegal at the federal level, but this is state law we're talking about. State law is clear. You can't discriminate, and that's the end of that. So we've seen a very sort of positive reversal in this trend over the last few years, where for about a decade plus, courts were ruling against us. For the last 5 or 6 years, courts have universally been ruling in our favor on this issue.
It's definitely awesome that there's been a shift over time as some of these newer states are coming on board. For those folks who are watching on Facebook, I am dropping some fact sheets in the comment section here, both from the NORML page as well as California NORML. And in that California NORML fact sheet, it does actually list out the states that ban discrimination for workplace drug testing, but also list some of those court cases that you're talking about and kind of how they are dealing with the issue of workplace drug testing. So that's definitely interesting. I know another thing that obviously comes up is sort of this issue around workers' comp. If someone's injured on the job, are they able to get reimbursed if they use medical cannabis?
Yeah, that's a great question. And until a few years ago, I think a lot of people would have scoffed at that question. They wouldn't even taken it seriously. But the fact is, the courts are taking this question very seriously. We now have a state Supreme Court rulings from a number of states where individuals have been injured on the job. They have used medical marijuana as part of their recovery and treatment from that injury. And then they filed claims saying they want financial reimbursement for the cost of their medical marijuana. Right now, the courts are largely mixed on how they have ruled on this issue. In the state of New Jersey, the courts have said that yes, employees who are injured on the job and use medical marijuana as part of their recovery are, in fact, eligible to have financial compensation through workman's comp. The state Supreme Court of New Hampshire has also ruled in favor of employees on this issue. By contrast, the state Supreme Courts in Massachusetts and Delaware have sided with the employers, saying that no, workman's compensation is not going to cover your medical marijuana costs. So again, this is an issue that's being decided state by state by the individual courts in those states. In many cases, there are lower court rulings that are favorable, but those cases are still on appeal. So this is going to continue to shake out in the years to come, but certainly it is not beyond the realm of possibility that in the future, there are going to be more and more states saying that, look, your medical marijuana costs are legitimate medical costs and workman's comp should cover them.
Right on. And it's interesting, obviously, that this has mostly been something that seems to have been working its way out through the court system. But is there an opportunity to also turn that into legislation at the local level, similar to these sort of workplace discrimination opportunities?
Certainly it could be. And again, oftentimes where the courts come down on the side of either the employer and the employee is in part based on how either strong or weak or explicit or not explicit the actual language is in the legalization law itself.
That makes sense. Right on. I know another sort of question that comes up because a lot of these places where it is legal to possess cannabis, to use cannabis as an adult, but still there are employers who are drug testing. Some of that has to do or is thought of having to do with federally mandated workplace drug testing guidelines. Can you speak to a little bit about that? And then if there's any chance of those changing in the future?
Sure. There are many individuals who are drug tested in the workplace, really due to no decision of that individual employer, but because there are federal drug testing guidelines that mandate certain employers drug test certain public employees. Commercially licensed drivers, for instance, are subject to drug testing, and that's because the federal drug testing guidelines mandate they be drug tested. The federal drug testing guidelines, by and large, were written in the 1980s, sort of during the height of the drug war zeitgeist during the 1980s. And random drug testing, suspicionless drug testing, really arose as part of that. The reason we have federal employees subject to drug testing came out of the 1980s. The reason high school students in certain jurisdictions are still randomly drug tested came out of decisions that were made in the 1980s and court rulings in the early 1990s. And unfortunately, like so much with federal law and with marijuana in particular, those guidelines, they haven't updated with the times. The federal drug testing guidelines today are pretty darn similar to the same guidelines that were first introduced and enacted in the 1980s. Unfortunately, we saw in September that, in fact, federal regulators were looking into amending those guidelines, but to actually expand the role of drug testing of federal workers and in the federal workforce. So in fact, going in the exact wrong direction.
Yeah, that's, like you said, interesting that so much of what we're dealing with when it comes to cannabis policy or marijuana policy was set decades ago. And a lot of that stuff is just through inertia still existing. So there's still a lot of work to be done to be able to change those sort of guidelines.
Yeah, and in fact, I would also point out that, in December, when we had the House of Representatives in the US Congress for the first time vote to repeal the federal prohibition of cannabis, which they did through the MORE Act, that there were certain federal agencies like the Department of Transportation, like Health and Human Services, agencies that are involved intimately with respect to drug testing guidelines or having workers in their agencies that are drug tested that were very vocal in their opposition to Congress enacting the MORE Act because they were concerned that it would, in fact, affect federal drug testing policies.
That's interesting. I guess every stakeholder's got their own opinion on that sort of stuff. We're seeing some questions come in through the comments. And just once again, folks, if you have any questions that you want Paul to be able to answer here, please go ahead and put them in the comments and I'll try to pull them up. One that kind of goes back to when we were talking a little bit about workers' comp here is, do people get disqualified from workers' comp if they test positive for medical marijuana they use at home?
So that's a very good question. This came up, I saw there were a number of comments about last week on our Facebook page, because we reported on a recent study that showed workman compensation filings decreased in states after they enacted medical marijuana legalization, and then decreased even more significantly in states that enacted adult use legalization. Now, there were many theories from the authors of this paper as to why that would be. Some of the thinking was that, and I should highlight, this was among older employees, not among younger employees. So the thinking was older employees were able to more readily return back to work because they were using medical marijuana. Some folks suggested in our chat that it was because individuals that are using medical marijuana are afraid to file for workman's comp for fear that their off-the-job use of marijuana will show up. I don't know the answer to that question. I believe it's probably one of these things where there's not a general universal rule, but it is going to depend from jurisdiction to jurisdiction and from claim to claim.
Super helpful. I appreciate you answering that. And for folks who want more information about that sort of decline in workers' compensation claims after adult use legalization laws, I did also drop that blog link here into the comments. So please feel free to check that out. I know there's, this, in addition to sort of the pre-screening or pre-employment drug screening and the random sort of drug screening, there's also the so-called performance testing as an alternative to traditional drug testing and urinalysis. Can you explain sort of the difference in performance testing versus a pre-employment drug screen?
Sure. This is, I think, a very important distinction to make, and it is one that is really important for us as advocates to make to lawmakers and to regulators and to employers. Because when we talk about ending this sort of discrimination, many employers get very nervous and they say, well, if we're not using urinalysis or blood testing to look for drug use, what sort of standard should we have? And in those instances, we talk about the distinction between drug detection tests versus drug performance testing. Our conventional, what we think of conventionally as drug testing, whether it's a breathalyzer on the side of the road or a urine screen or a blood screen, none of these technologies actually test the subject's performance. They don't have the ability to do so. They simply look for the presence of certain chemical compounds, either in the breath, blood, or urine. The presence of those compounds, when it comes to cannabis, tells us nothing with respect to when this person was last exposed to cannabis, whether they're under the influence of cannabis, or whether they're an occasional or a frequent user of cannabis. So essentially, no information that would help an employer determine if somebody is under the influence can be determined from the very tests that are being given. By contrast, performance testing technology does not involve some sort of search of one's bodily fluids. Instead, we use scientifically validated cognitive tests of performance, such as estimation of the perception of time or the passage of time, such as short-term memory tests. So we use these sort of computerized tests to see if a person's results vary from a baseline that they have set previously based on their performance. So a person could essentially go into an office. If they were suspected of being under the influence, they would be asked to run through the same battery of tests that they have previously done and they have achieved a standardized baseline, and then we'll see if their performance deviates from that baseline. And if it does, then further testing may be done. But in this respect, we're actually measuring how a person performs on the job. We're not looking for the detection of certain compounds or metabolites, byproducts in their blood or urine that tell us nothing about whether a person's impaired or whether they may have used cannabis in the last few hours or in the last few months.
That's super interesting as a methodology to be able to figure out whether somebody is, as you're saying, performing at their baseline or above or below their baseline based on any sort of various factors, right? I feel like you could be performing under the baseline if you're just tired at work or other sort of
Exactly.
things.
And in these cases, again, the sort of cognitive tests that are being used are tests that we know, that we have scientific evidence that a person's performance on these specific tests varies when they're under the influence of cannabis.
And so is this something that's just been tested out in sort of a trial sort of study standpoint, or is this stuff that's actually being implemented in workplaces?
Both.
Okay.
There's, for instance, a product known as the Alert Meter, which is a standard performance test that is being marketed to employers and is available on the market. There is other technology like Druid, which is essentially an app for your phone that allows a person to try to self-regulate to see if they're impaired. And that technology has gone through scientific clinical testing. You can read peer-reviewed studies about the use of Druid. And we expect to see that sort of technology and offshoots of that technology become far more prevalent and accepted in the years to come.
What a wild thing to think about, actually having sensible or workplace drug testing policies that aren't, as you say, just testing for metabolites or inactive substances in your body, but active, actually how you perform as an employee. So that's super interesting. I know we're going to wrap up here in just a couple minutes. We're running out of questions on the drug testing side, but obviously a question that we'll get anytime we come live is, when is it going to be federal legally? So can you maybe just give a super brief sort of update about sort of what's going on at the federal level and maybe even how that ties in to this broader conversation around workplace drug testing?
Sure. Unfortunately, it's not really a brief answer I can give you, because when people ask, when is cannabis going to be legal at the federal level, I feel like it's a very misleading question, because the legislation that's pending in Congress to amend federal marijuana laws or to end the federal criminalization of marijuana, this is legislation to repeal the laws that exist on the books concerning marijuana. Specifically, the cannabis plant is a Schedule I controlled substance. It is categorized in Schedule I of the Controlled Substances Act of 1970. That's where the federal government gets its authority currently to impose criminal prohibitions on cannabis. The legislation pending before Congress would remove marijuana from Schedule I, thereby repealing the federal government's authority. That, however, does not mandate that states do the same thing at the same time. So just as the federal government repealed the prohibition of alcohol almost a century ago, thereby leaving that individual decision up to the states. And keep in mind, after a federal prohibition of alcohol was repealed, some states like Mississippi and Missouri continued to criminalize alcohol for decades afterward. Just as we had that example with alcohol, we're looking at the same example with cannabis. If the federal government moves forward and repeals prohibition, a state like Alabama, for instance, where marijuana is still illegal today, it would continue to be illegal after the repeal of federal prohibition. And if you lived in Alabama and wanted to have legal marijuana in that state, the burden would then be up to local and state lawmakers in that state to change their own state policies. So I would dare say, as an update, we are close, as in within 1 to 2 years of repealing the federal prohibition of marijuana. But once that happens, just like after the repeal of alcohol prohibition, this is going to continue to be an issue that is addressed state by state. And there are going to continue to be at least a couple dozen states, even after the repeal of federal marijuana prohibition, that are still going to need to repeal or amend their own state criminal policies.
I think that's super important for us to be able to put into context, even as it relates to this conversation about workplace drug testing. We obviously talked about some of the changes that have happened at the local level. It really comes down to getting involved, right? Which is what we do here at the National Organization for the Reform of Marijuana Laws. We try to act as a vehicle for you in your local areas to be able to make changes to these medical marijuana and adult use marijuana laws. So if you in your state feel like federal prohibition isn't necessarily going to benefit you directly immediately, then you should get to work at your local level, whether that's joining an existing NORML chapter or whether that's reaching out to norml.org and setting up a chapter of your own if there isn't an active chapter in your area, and make sure that you are taking control of the future. We're doing what we can at the federal level to make sure that, as Paul says, we repeal the federal prohibition, but ultimately it's up to you guys in your local spheres of influence to make sure that those laws and those ideals are reflected in your local communities as well.
Yeah, absolutely. And to give folks some perspective, there may be a handful of pieces of federal legislation to address this issue at the federal level, but there are literally hundreds of marijuana related bills that are currently pending at the state level. And if folks go to the NORML webpage, if you go to norml.org/act, you'll find a map of the United States. Click on the state of interest to you, and it will bring up all of the pending marijuana related bills in that state, and it will provide an automated mechanism for you to provide your address and to send letters and emails and to contact your state elected officials and tell them to either support or oppose those pending pieces of legislation. A lot of times people are under the impression that nothing is happening legislatively in their state, when in fact, there are literally dozens of marijuana related bills that we're tracking, that we're supporting, and in some cases that we're opposing in virtually every state in the nation right now.
Absolutely. There's always something going on. And even as close as we are to the goal line, we still need all hands on deck to help try to push that ball over. So we definitely appreciate the work you're doing here at NORML, Paul, and obviously everybody who's tuning in here to Facebook. Please do make sure you go to norml.org/act and make sure that you're getting involved in your local area. Is there anything that you want to sort of leave anybody with here, Paul, or anything else you want to make sure that we cover?
I would just add, I would sort of end with this. Drug testing is still prevalent, more prevalent than it ought to be in America, certainly in the workplace, but it is also on the decline. I cut my teeth doing this work in the early 1990s. Like I said, just a few years removed from the drug war zeitgeist of the 1980s. In the late 1980s, over 80% of large companies randomly drug tested their employees, or they gave them pre-employment drug screenings. Today, that percentage is below 50%. So even organically, there is a better understanding and an evolving understanding among employers that drug testing, particularly suspicionless, randomless drug testing, urinalysis for marijuana, that none of this makes any sense. And employers, even without having to be mandated to do so by a change in the law, many employers are abandoning this policy.
That's definitely a great note for us to be able to lead on, and that there's plenty of progress that is already being had and more progress to be had for those of us who are going to continue to keep up the fight and try to move the ball forward here. So, Paul, really appreciate your time today and being able to explain sort of the latest as it relates to workplace drug testing and cannabis legalization. And we'll be sure to come back on here with some other live streams on other topics that we can dive a little bit deeper on and answer your guys' questions. So until next time, we appreciate everybody tuning in. And Paul, we appreciate your time. Thanks so much for everything you do.
You're welcome. Thank you, Kaliko. And thanks to everybody who checked out the live stream.